Good morning, everyone. Thank you so much for joining us this morning for our final series of our three-part series. Today's series is called Workers' Rights and Finding Work. I do want to mention that part one and part two have been uploaded on our website, and we will drop the link to those shortly in case you want to watch any previous recordings. But as I mentioned today, today's training is focused on immigration. Oh, I'm sorry, workers' rights and finding work. Today, our learning objectives are that we will understand an overview of immigrant work, rights, and protections in California. Also, we will learn to navigate legal resources and government state agencies to enforce these rights. Additionally, we will go over which employment-related rights protect all workers regardless of immigration status, and then which employment benefits pertain to documented workers specifically. Lastly, we will leave this webinar with a referral sheet to where immigrant workers can look for work, and a discussion of patterns of employment agencies and immigrant communities that raise red flags. We will be dropping those worksheets in the chat towards the end of the webinar. However, if you are not able to download it, don't worry. We will make sure to send it out with the email after this webinar is over. Just a few housekeeping reminders before we get started. As I mentioned previously, this webinar is recorded and will be uploaded to our website. We will be emailing out all the materials shared and the slides along with the recording. So watch out for that after a few days of this webinar wrapping up. And then we will be taking Q&A questions throughout the presentation. So if you do have some, please make sure to leave any questions in the Q&A box on this webinar. And then please continue to introduce yourselves. Let us know what org you're from in the chat. But please make sure to use the Q&A if you do have any questions. And then lastly, we kindly ask that at the end of the webinar, you take a few minutes to fill out our evaluation as it helps us understand how we did and what trainings we can put on for your community next. With all that being said, I'm very happy to announce that LA Best Babies Network and the Consortium is super grateful to be partnering with Neighborhood Legal Services of Los Angeles County for this training. Today, we have two wonderful trainers joining us. The first trainer, a little bit about her. Her name is Deborah Sudomara. Deborah was an immigrant workers' rights attorney at the Legal Aid Foundation of LA from 2005 to 2013, enforcing rights against wage theft, unemployment insurance denials, and presenting Know Your Rights presentations all over LA County. She recently joined the Neighborhood Legal Services of LA County in the same role in 2022. And then our second presenter is Amy Yu. Amy is a staff attorney on the workers' rights team at Neighborhood Legal Services of LA. She's an immigrant from Hong Kong and currently lives in Monterey Park, California with her two cats. Amy joined NLSLA as an immigration attorney and transitioned over to workers' rights team at the height of the COVID-19 pandemic, which allowed her to heavily focus on unemployment insurance benefits administered through the Employment Development Department. With all that being said, I'm super excited to introduce Deborah and Amy, and I will hand it all to you to get us started with the presentation. Thank you so much.
Thank you, Anna, and thanks for having us, everyone. Again, my name is Amy. I'm one of the workers' rights attorneys at Neighborhood Legal Services of LA. And my colleague Deborah here is also on the presentation, and we will be switching off doing certain parts of the presentation. So let's get started. I'm not going to go over who we are because I think a lot of you have already seen this slide. But for our team, we do mainly employment law, and that covers wage theft, wage and hour laws. We provide counsel and advice on sexual harassment, discrimination, retaliation, including immigrant rights-based retaliation. We also provide assistance with unemployment benefits, state disability insurance, paid family leave, and we also help with issues related to getting sick leave and getting job protected leave. So any issue, and we also provide some information about wrongful termination. So any kind of issues that come up over the course of your job or in the workplace, you can refer clients to us for help, or for, if at the very least, for some counsel and advice, if not full representation, at least at the administrative agency level. So that's just a short recap of what we do. Our services are free, and we assist mainly low-income individuals who live in LA County. So, an overview of our presentation today, we're going to touch on several topics, and these are all, full 1 hour presentations in itself. So, they're going to be very brief and have a lot of information. But again, if you have any questions, just feel free to drop them in the chat, and we'll also make sure to stop between sections to ask for questions. So, first, we're going to go over wage and hour law, which is also called wage theft, and this covers minimum wage, overtime, meal and rest breaks, misclassification, vacation pay, and things like that. And the second portion, we're going to do EDD benefits, including unemployment insurance, state disability benefits, and paid family leave. And this is just general eligibility requirements, how to apply, and how to appeal. And then the third portion is workplace discrimination, harassment, and bullying. So what does it mean to be discriminated against, or the legal definitions of discrimination and harassment, and what examples of what that can look like? And the fourth portion is retaliation and at-will employment. And the fifth portion is getting time off, and that can include sick time off or protected job leave and medical leave. So the first portion we're going to talk about is wage theft. And wage theft is a very prevalent issue, as I'm sure you're all familiar with because you all live in LA County. And this occurs in many ways. It's not only when your employer pays you less than minimum wage or not paying you at all. Um, Basically, if you're entitled to any payments that you consider as wages and you don't get paid that, that is a form of wage theft. So that can include paying you less than what you agreed to, either by made verbally or made in writing. And this can also look like the employer taking your tips if you work at a restaurant. So in cases where we see a worker whose tips were deducted from their paychecks, or the manager taking the tips for themselves, that is not allowed. But what is allowed is when tips are pooled and shared between employees. That's allowed, as long as none of that counts towards the minimum wage, and as long as that is not used to compensate the owner or the supervisor or the manager. And wage theft also looks like when uh, you're not paid overtime, you're not paid for split shifts, you're not paid promised vacations or bonuses, and when you're not paid your final wages when you separate from your employer. So when you leave your job for whatever reason and they don't pay you within a certain period of time, that is also wage theft. And then some other common situations is when you're denied a meal break or a rest break, when you're not allowed to use accrued leave time, or when you need to use sick leave. It can also look like when uh, there are unauthorized deductions from your paychecks. So when you look at your paycheck and you see all these, little different deductions going out and you don't recognize them, or you don't remember um, making an agreement to pay for them that is not required by the state, then those could be unauthorized deductions. Or when the employer pays you using either their personal checks or business check, but when you try to deposit it and the checks they bounce back because of insufficient funds or a wrong number or anything like that, that is also a violation under the California Labor Code. And the last one is uh, when a worker has to pay for their own work-related expenses and they don't get reimbursed. And this is most common in maybe like a uniform, right? If you're required to wear a uniform to work and you have to pay out of pocket for it, but the employer requires you to wear that to work, then they should be paying you for that. So there are some minimum wage laws to be aware of, and this can include, just the general state minimum wage. And that is $16 per hour for all employers in 2024. That is the state minimum wage, but in California, there are many different minimum wage ordinances, depending on, the city, the industry, and whether the city you live in is unincorporated or not. So there's a lot of different ways to determine which minimum wage is applicable to you. And the minimum wage that should apply to you depends on the city that you work in and not the city that you live in. So if you happen to live in a different city from the one that you work in, just always check to make sure that you're following the city that you're working in. And then if there is a difference, and which there most often is, you always choose the higher minimum wage that is applicable to you, right? So in certain cities, you're in some maybe city of LA, I think it's maybe 16.78 right now per hour. But since the state minimum wage is only 16, you always want to pick the higher minimum wage that is applicable. And starting this year, even for fast food workers, they get $20 an hour, right? So despite the fact that maybe you're a fast food worker in LA City and it's in California, you're gonna be getting $20 an hour. And so it's important to, check the location of your job and and your paychecks to make sure that you're getting paid correctly by the hour. And every worker has the right to minimum wage. The some exceptions include if you work for your spouse, parent, or child, then you do not have the right to minimum wage. So in these situations, we see that, sometimes in like a restaurant business or some other family business where the employer is maybe your husband or your parents and you work for them, as in they hire you, then they're not obligated to pay you minimum wage. You also can't agree to be paid less than minimum wage. So you can't waive your right to be paid less than minimum wage. So, meaning that you can't contract or make an agreement to say that you're going to be paid less than $16 an hour for whatever reason. You just can't because it's your right. And then again, tips do not count towards minimum wage. So if you're a restaurant worker, just make sure that when you count out your tips at the end of the day, make sure that your base hourly rate is still according to the minimum wage. And for in California, there are two types of overtime and double time, and that's a daily overtime and a weekly overtime. And for your daily overtime, that is more if you work more than 8 hours in a day. And so your employer has to pay the worker at least 1.5 times your regular hourly rate for each hour worked. And so if you work more than 8 hours a day or 48 hours a week and the first 8 hours worked on the seventh consecutive workday, then you have to be paid 1.5 times extra. For double time, that is when you work more than 12 hours in one day and more than 8 hours on the seventh consecutive workday. So in that situation, you have to be paid double time, and that is twice your regular rate of pay. You also can't waive the right to overtime. You can't agree uh, with the employer that if you work extra hours, you're doing this willingly and you will not accept overtime because you just want to work the extra hours. So you are obligated to be paid for every hour that you worked according to the California labor law. So if the fact that you work even 1 minute overtime, you have to be paid that extra overtime. Now, the employer can uh, refuse to let you work overtime. They can say that you're not allowed to work overtime, and if you do, then I'll write you up for it. That is allowed, but the fact that you actually do the overtime, they still have to pay you for it. They can write you up for working unauthorized overtime, and you can face some consequences for it, but you still have to be paid for every hour, every minute that you're worked. And in California, employees are entitled to a 30-minute unpaid meal break if you work more than 5 hours a day. And then they also get a second meal break if you work more than 10 hours a day. You can waive the first meal break period if you both agree to it. And then you can also waive the second period if you both agree as well, but only if you didn't already waive your first. You can also waive it if your work period is no more than 6 hours for the day. And for meal periods, the workers have to be relieved of all duties, meaning that you can't be called to the job while you're eating your food. And if you are required to stay on the site, on the work site, during the meal break, it has to be paid. And this is called an on-duty meal period. And that's when, maybe the nature of the work requires it. Um, so for example, if you work as a security guard or a nurse and you're the only one on the shift and nobody else can come cover you, and this is a type of work where it's maybe remote or maybe emergencies happen and you have to take care of whatever job responsibilities you have, and you just can't leave anyone alone in that 30 minutes. So in that nature of the work, then you have to be paid for that meal hour. It can also be on duty if you agree to it in writing between the worker and the employer. And these these work times for meal breaks, for overtime, for whatever hours worked, the employer has the responsibility of keeping track of making sure that you are paid correctly and that you're clocking in and that you're paid according to the amount of hours worked and that you're taking your breaks. So workers are also entitled to taking a 10-minute rest break for every 4 hours worked, and these are paid rest breaks. They don't have to take it if it's less than uh, 3.5 hours of work per day. And so the amount of rest breaks depends on how many hours you work per day. So the breakdown is every 3.5 hours, you get one, every 6 hours, or at the 6 hour mark, you get two, and then at the 10 hour mark, you get three. And if the employer doesn't give you these meal and rest breaks, or if they tell you not to take them, or in any way somehow prevent you physically or otherwise from taking them, then that is a violation of California labor laws, and these violations are what we call premiums. And so the penalty for that is you will be paid 1 hour of pay at your regular rate for each workday that you missed a meal or a rest break. And this kind of violation, along with minimum wage, overtime, um, you can file these violations with the California Labor Commissioner's Office, and you can claim for up to 3 years of violations. And so another type of worker that we've seen that employers try to misclassify um, are independent contractors. And this is important because independent contractors are not protected by California labor laws. Everything that I've talked about regarding minimum wage, overtime, meal and rest breaks, double time, they only apply to employees. So workers who are classified as employees, they're paid W-2s or cash or anything like that, as long as they're not paid in 1099 tax forms, because that is an independent contractor. And so a lot of employers would want to purposely misclassify a worker as an independent contractor so that they don't have to pay um, these workers minimum wage or overtime, right? In addition to a lot of other things. And so there are tests and factors to look at to decide whether a worker is an independent contractor or an employee. But the important thing to note is that by default in California, there's a presumption that every worker is an employee. So by default, every worker is an employee, and it's up to the employer to prove that the person that they hired is an independent contractor. And so every person who's hired not as an independent contractor has to be paid minimum wage, overtime, and all of that. And so I'm not going to get into, the factors that make somebody an employee or an independent contractor, but a worker cannot be cannot agree to be an independent contractor either. So the fact that an employer makes you sign a contract that says, I agree to work as an independent contractor, that is also invalid. It's really a legal definition and a test to see. So if you think that anyone you know has been either accidentally or intentionally misclassified as an independent contractor to get around minimum wage laws and labor laws, you can always try to or talk to someone about it, or talk to an attorney about it, or talk to us about it, and we can help you assess. Another type of employee who may overtime laws um, is what we call the professional um, is what we call exempt employees, because they fall under certain exemptions like a professional, administrative, or an executive exemption, because these are salary, mostly of the time they're salary professionals who make twice the minimum wage. There is a minimum salary that they have to make, and you have to look at their job duties to determine whether they fall under this exempt employee status. Okay. For a vacation and holiday pay in California, there is no law that requires an employer to provide vacation days or holiday pay unless, so there's no law that requires it, but if the employer has this policy written in writing, like an employee handbook or as part of their rules, then they have to give that to you. And if they do promise you that you can accrue vacation pay, then um, these types of payments are treated as wages, meaning that they have to pay you out when you leave. And they also cannot have a use it or lose it vacation policy, meaning that they can't tell you to use it by a certain amount of time, or else you will no longer have it, next year. So we see this happening when maybe HR tells you your vacation is at 10 hours right now, and if you don't use it by the end of December, then it'll reset to zero by next year in 2025. So these policies are illegal. Um, the only thing that they can do is if they have a policy letting you accrue it, they have to tell you how it's accrued, and they have to tell you how much time you can accrue. And they can also put a cap, right, on the maximum amount that you can accrue. For all of these wage theft laws that I talked about, they apply to all employees, including any employees, regardless of immigration status. So it doesn't matter what type of visa you have, doesn't matter if you're undocumented or if you have DACA or TPS, as long as you worked as an employee, you are protected by the California Labor Code. You get the right to minimum wage, you get the right to overtime and meal and rest breaks. And so, if anyone has experienced a violation in any of the topics I talked about, they have the options to file a claim with the Labor Commissioner's Office, or what is known as the Division of Labor and Standards Enforcement. This is an administrative government agency, and it's an informal kind of proceedings where you start out by, filing a claim, and then you do a settlement conference that's mediated between the Labor Commissioner's Office, one of their deputies, you, the worker, and the employer. And then if that doesn't resolve in itself, then the case goes to a hearing with a hearing officer, and there will be no judge, but you have to prepare, evidence, exhibits, you can bring witnesses, and you have to prepare kind of like a legal argument. But there's not going to be a jury, it's not going to be like a court, and it's less than formal than an actual court proceeding, and it's not as expensive. In fact, it's free because there's no costs or anything unless you hire an actual attorney to represent you in these proceedings. But in these labor commissioners proceedings, you can represent yourself. You can bring an advocate who does not have a legal background to represent you. You can bring anybody to come and help you in these proceedings. And so these are more worker friendly, they're more cost friendly. The drawback is that they are taking quite a bit to process these claims. It's taking maybe about 3 to 5 years to resolve a wage claim at this point because of just how backlogged the agency is. So that is a drawback. And then another option is small claims court, and that is for claims of wages up to $12,500. And in that kind of proceeding, you cannot bring an attorney, neither side can bring an attorney, and the judge may not be as familiar with not immigration, with workers' rights laws, but they um, but you can prepare yourself to attend the hearings and to present your argument. And these proceedings can cost a little bit of money because you have to pay for the filing costs of the documents, but you can get a fee waiver. And an advantage of this proceeding is that it ends relatively quickly. You can get a judgment within a year. And then the last option, of course, is just to find a private attorney and file a lawsuit to sue your employer in civil court. And in the labor commissioner's process, regarding the immigration status, they will not question you about your citizenship, your status, and they will not share this information if you somehow report it to any other agency. Everything is kept confidential to that agency, and it will not get reported to, places like ICE or anything. So again, I talked about these options. We always advise clients to gather information and keep records of their hours worked, of their paychecks, if they don't get paid direct deposit. Every paycheck, look at the pay stub to make sure that they're paid correctly and that there's nothing being illegally deducted, and that they are paying into whatever state funds that they're supposed to be paying into. So, because a lot of employers, um, like especially small business owners, don't keep their own records. They don't keep timesheets. It's really up to the worker themselves to keep track of their own work schedules and work hours, so that at least they have something in documentation and in writing to show that they actually work these hours. Because having something is better than having nothing at all. Um, and before we do any of the wage claim filings with the LCO or small claims or Superior Court, we help them draft a demand letter to the employer first to see if the employer is aware that any violations has taken place and whether they're willing to just pay up, right? If we can get the employer to pay back the worker wages without going further into any of the other steps that I mentioned, then that's all better for the worker, right? We save them time and resources. And most of the time, they're very happy to get their wages relatively quickly. Okay, so that was the wage theft portion. I'm going to stop here to see if I have any questions, and then Deborah will take on the UI portion.
Hi, Amy. No questions have come through. Thank
Okay,
you.
okay, perfect.
Hi,
Oh, wait, actually, one just did. I'm so sorry. Someone asked, if the employee is paid in cash, not checks, would they still be able to process, or would they still be able to do this process to challenge wage theft?
Yes, they would. It would be a little harder to prove that uh that they were owed wages, because if you don't have like a receipt or anything showing that you were paid on the day of, right? Then it's hard to prove, one, that you're a worker there, and two, that you were or were not paid. So if you can get a record of saying, even just writing it down yourself, saying, I got paid 200 today, that could help. Even if you were paid in cash, as long as there's some documentation showing that you received this much amount of money, showing that you worked this many of hours, like that is better than just straight up taking the cash and like having no paper trails of it.
I see there's also another question asking if the employee used a fake work permit, do these protections apply? So if we're only talking about the hours that you worked and then you weren't properly paid for something, the work authorization or actually using fake permits should not affect your ability to recoup those costs. But in terms of other types of law, like for example, if the employee is fired for using a fake work permit, whereas in California, which we will get to, there is, you can be fired for any reason. It is at will. So the fact that this person used a fake work permit and was fired, they may not be able to then say, well, I think I was improperly or wrongfully terminated and I'm seeking X, Y, and Z, because that would be a valid reason, even though you don't need a reason at all. So just in terms of getting your wages, there should not be any kind of hindrance, but it could affect other types of employment claims. And one of them could be what we will delve into next, which is the unemployment insurance administered by EDD. But before we get to that, I know that because all of you guys are providers and you're speaking to clients, and we don't expect you to know every single detail of what Amy had covered because there are so many nuances. I think the biggest takeaway is the idea that if you come across somebody who says anything about the way they were paid, their paycheck stubs, I think the best way to prepare them to then come to us so we can, quickly assess their claim and give them the appropriate resources is to have them prepare very basic things like collecting their paycheck stubs if they have any. If they don't, and if they're getting paid in cash, as Amy alluded to, the best advice would be, start documenting things that are happening. So even if it's just your testimony, at least you've written down, okay, on this day, my supervisor so-and-so promised me a break time and I was denied it. I mean, that's still better than having no records at all. If you do get paid cash, but you don't get a paycheck stub, writing down the hours that you worked and then, a quick notation of how much was paid, that's always helpful. So if they can gather all that information before coming to us, that is helpful because, those are very basic things that we need to know in terms of who did you work for, names, timelines are always important. When were you hired? When did the problem start to occur? So all of these things are very important to have the clients just sort of have an idea of before they come to us. Just makes it a little bit quicker. And then once they do come to us, I just wanted to highlight that there are many different places that they can go. So they can be directed straight to the Labor Commissioner's office, which would be the state agency to reclaim some of these benefits. But there are also worker centers out there that are very specific to industries. So sometimes a worker might feel more comfortable going to, say, a garment worker center. That's all, they deal with. It's part of a collective that helps workers. There's a restaurant collective, there's a Black worker center. And they all belong to a special network also. We have not been in too much contact with them because they tend to have their own sort of legal team within that, but we certainly know of them so that we can say, call the Thai Worker Center or call this one if you're more comfortable. And of course, if they want to go through us, that would be great too. So in preparing the client to even call us first, I think it's important to gather all those documents and information, as well as just knowing that if something does go awry, to keep in touch maybe with coworkers or who could potentially become witnesses for them. In our experience, because of the delays at the Labor Commissioner, I feel like there's always strength in numbers, but specifically with that agency, if you have an industry-wide problem or a company-wide problem, it's going to be easier for them to highlight that as something that they want to investigate as opposed to just one person coming forward. So those are some sort of like practical tips about when you get a client who raises some of these issues. Always, of course, you can refer back to this PowerPoint. You can give us a call, you can have them call us directly, but it's that fact gathering that only they can do that is the most helpful for an advocate. And the other thing, I was just looking down the list of everybody who's attending, just wanted to highlight because it relates to lactation rights in the workplace and rest breaks. So in California, you do have a right to a private space with a reasonable amount of break time. As we mentioned, break times are not paid, so you're supposed to get those 10 minutes, but if for some reason you use it for lactation and it runs over, they don't have to pay you beyond the 10 minutes, but they do have to make that time available to you. We'll get to this also at the end of the presentation, but there are some amazing fact sheets that Legal Aid at Work have developed, and they have a great one specifically on this. I think that's probably one of the most important things that we can impart to you of like where to go, where can I just quickly download a sheet, hand it to the client. It's meant to be a quick resource, something that's easy to understand, and it tells you where exactly to go. That's always very helpful, and it's something that we cannot cover, obviously in this short amount of time, but that would be a really important resource as well. Okay. Any questions on that material before we head over to EDD World? No, don't see. Okay. So the Employment Development Department, or EDD, administers two types of work-related government benefits. This is probably an easier identifying issue for you all because your client or your, the home that you're visiting or whatnot might say like, I have some paperwork, and that famous logo will let you know that you're dealing with one of these benefits predominantly, and we'll get into some of the other ones that they handle. So this is an easy one to say, okay, I know they can call NLS. I know they can go straight to EDD. I know that this one is easy because this is the two things that they administer. So let's get into the first one, which is unemployment insurance benefits. And what that is it's a benefit that go to workers who have been unemployed through no fault of their own, or who have reduced earnings. So this could be temporary, it could be partial unemployment. Sometimes a worker might have to reduce their earnings for, like it's a seasonal work, and so their wages drop. They might have a layoff, or they might be fired, or they might be, quit for reasons that we will get into in terms of whether or not they qualify. But it's to help you find another job, and it usually is a benefit that ranges from 40 to 450 per week, with a maximum 26-week period. Next slide. Okay. This is just to sort of highlight one of the eligibility criteria is that you have to have worked and earned enough earnings in a period before you apply. So for example, if the person is going to apply today, we would be in October, they would look at the highlighted quarters of their previous employment to ensure that both they have eligible wages, which will determine how much they get per week, as well as whether or not they can even get it. So that there's a calculator that you can actually go onto the EDD website where you can enter when you apply, and then they could just calculate, how much earnings you've had for those quarters, and it can give you an estimate of how much you could expect to get. I think the number one question we always get is, if I'm fired, do I still qualified? If I quit, am I still qualified? What if I'm injured? And so the basic eligibility is best described where, this is a benefit for people who, through no fault of their own, find themselves with a loss of income, either partially or totally, but they are able to work. They're physically able to work. They're available to work. They can look for work. So this is not for someone who decides to stop working altogether because they want to get a higher degree or go back to school, or maybe there's issues with childcare and they cannot work a regular schedule anymore. This is for someone who is actively looking for work. So that's kind of the main criteria that should, give you an idea of whether or not somebody is qualified. But of course, they should be encouraged to apply anyways. But those are the common sort of like, if I quit, you have to show that you quit for a good cause. It would be, what other steps did you take in order to save your job? If something is terrible going on at your job and you can't work under those conditions, did you report it anywhere? So that's when you quit a job and whether or not you're going to be eligible for unemployment. And then if you're terminated, there's always this misconception that if you're fired, you'll never get it, which is not true. It's actually quite a high standard to not qualify for unemployment insurance. You have to show that it was not for misconduct, which just happens to be a legal term that states, you did not intentionally try to harm your employer's interest. So if it's just that they weren't happy with your work, or it just didn't work out, or maybe you were tardy once and you got let go, you'd have to show that you consistently disregarded their interests, you were warned several times and you just didn't care. Or if the incident that caused your termination was serious enough, that could also be taken into consideration. Okay, there we go. So some general tips that we always give, especially if the claimant is limited English proficient, is to apply on paper rather than online. And the reason for that is that even if they have somebody helping them, if they don't get the wording quite right on the application, or sometimes we've seen issues with translation between saying laid off versus terminated. It could be translated differently. That verbiage can affect your eligibility. And if it's determined that you use the wrong word, perhaps, they could say that you will be penalized for making a false statement in order to get unemployment. So that's just something to think about. We do assist limited English proficient clients, navigate the initial application. For all others, we kind of only get involved once they've been denied. But that is just something to kind of be aware of, depending on the people that you work with. And if they are proficient, it is always quicker to do it online, because then a portal is set up. We can review what's going on, what was denied, which weeks were paid, etc. So that's always helpful. So as we mentioned before, one of the goals is to talk about which rights and benefits apply to documented workers and which for undocumented. This one in particular only applies to documented workers. If you remember from the eligibility, we said you have to be able and available to work, and part of that availability would mean that you have work authorization to work. So that's why this particular one applies to only workers who are documented. I think there was a question, would not being able to find childcare be good cause to quit? Okay, so we actually do sometimes get that case. And I think that also occurs when workers are consistently late because they have public transportation issues or something like that. If you are deemed to have to quit your job because you can't find childcare, unfortunately, that runs into the eligibility issues of unemployment is only for you to then find other work so that you are able and available to work, right? So in that process, it would not be for good cause if you can't find childcare, because then you would not be eligible to also be looking for work because you're dealing with the childcare issues. Of course, there's so many other nuances to that. Like if you just can't find childcare at all and you have to take time off, this is not the benefit for that. If you're in a transition period, you just gave birth, you're going back to work, there are some hiccups, and your employer just, after 2 tardies or absences, just fires you. If you can make clear that you're resolving it and you just weren't given enough time, depending on the reasonableness of it, that could be, you can still show that you would qualify for unemployment insurance. So there's a lot of nuances. I think if they are denied or if they have any questions about the application process, send them our way. We can help with everything dealing with EDD. And I'd also like to mention that, in fact, we have other partners that we work with in the Southern California area that deals with low-income workers. And they have all decided that EDD is not an area that they're going to focus on right now. And so it is just us and another legal aid called the Legal Aid Foundation of Los Angeles who are doing these claims. So if these do pop up, there are a few up in the Bay Area, but they tend to, favor residents who are up there. So in the Southern California, Los Angeles County area, this is the only to organizations that can help with EDD benefits. Okay.
There's another question.
Yeah, can workers share their wages with their peers? Can they get reprimanded for such in California? Share their wages. I'm assuming that this is dealing with, in particular, EDD as opposed to like trying to get benefits. I don't think, I mean, they wouldn't qualify for this particular benefit if, I don't know if you mean like working under one social security number in order to get the benefits, but I do think that would run into some issues with fraudulent misrepresentations to EDD. But I don't know if that was like a general question or specifically for unemployment insurance and EDD.
Okay, shall we move on?
Yes.
Okay. Okay, so then the next part, our next program is the state disability insurance and paid family leave. And they're kind of grouped together because they're the same application and same portal to access for when you file for these benefits because the eligibility requirements are basically the same except for a few minor differences. So for SDI, this is a short-term wage replacement program for workers who are out of work due to a non-work related illness, injury, or pregnancy. And this illness or injury has to be non-work related, okay? Because if it is an injury that was occurred at work or related to work, then the worker has to file for workers' compensation first. And then if the employer determines that it wasn't work related and they've been denied workers' comp, then that's when they can apply for SDI. And to be eligible for this program, this disability has to cause them to have an actual loss of income for at least 8 days. So if this worker is getting paid sick leave or they have accrued PTO, then they wouldn't qualify for this program, right? Because they don't have any loss of wages. There's also a deadline to apply for this program. It's no later than 49 days from the first day of disability. You can file late, but you do have to explain to EDD why you filed late, and you have to show something called good cause, and that just basically means that you didn't do this out of neglect or intentionally waited long to file. Um, the other eligibility requirement is that you must have paid into a fund called the CASDI. And that's why looking at your paychecks is important because if you are get paid W-2, then on your pay stubs, it will show that every time you get paid, taxes are taken out, and part of those taxes go into the state fund. And if you don't pay into this fund, then it's hard, then you will likely not qualify because you never contributed to the fund. And you have to have earned at least just $300 in the year before you try to apply for SDI. And this program pays you at 60% per week up to 70% of your base income. And the longest amount you can claim on SCI is 52 weeks max, so a whole year. If your injury or disability lasts longer than 52 years, then you can try to either transition to Social Security disability benefits, or you can ask your doctor to extend it if you still have a balance remaining. And so there's also a link to calculate how much you could get if you apply for this program, depending on your income. And then there's also a requirement that you see a doctor and get a medical professional to certify for your disability. And this is just a form that they complete. You don't have to do anything. As long as you complete your portion of the application and then go see a doctor and then they fill that out, then that's pretty much it for the process. Again, they have to be either still employed or looking for work at the time that their disability begins. They earn $300 in wages that were subject to SCI deductions, loss of wages. And then one important thing to note is that citizenship and immigration status does not affect SCI eligibility. When you compare it to unemployment insurance, well, when Deborah was saying that you only immigrants who have work authorization are eligible for unemployment insurance, but here they don't have to show evidence of legal work authorization. They don't have to show immigration status. They don't have to show citizenship. All they have to show is all these things that I just talked about, as long as they can show that they earned $300 in wages, loss of income, they worked for an employer, they have an injury. That's it. Because EDD in this particular benefits process doesn't ask you about whether you're a citizen, whether you're an immigrant, or what status you have. They don't ask for like a work permit or anything. However, on the online application, they do ask you for a social. And if you if you are a worker who is using a different social, like one that's fake, either one that's not yours, or if you don't have legal work authorization, we recommend that these workers apply using a paper application and then explain, how they earn their wages, what name that they use to earn these wages, who their employer is, because the important thing is to link your wages to your actual name to show that you are an employee and that you worked for a certain amount of time and that you earned $300 in wages. And if these workers don't get paychecks or a W-2, and so meaning they never contributed to the SDI fund, then that's the employer's fault, right? It's not on the employee's fault that they never paid, because this is, again, misclassification, right? This is when an employer treats these workers as independent contractors. And so purposely don't treat them as W-2 employees. And so as an effect of that, they don't contribute to SDI. But and in reality, a lot of these workers should have been paid W-2s, and so they could qualify for SDI, but because of immigration status, they don't have the proper documents to show that they are W-2 employees. And so a lot of them qualify for SDI but are left out of this program. And again, I went over the medical certification. So for that program, that is for workers who are injured because they are unable to work because of an injury or illness. Paid family leave is a similar program for workers who are unable to work, but it's because they need to bond with a new baby or because they want to care for a close family relative who has a serious health condition. And these relatives could be a child, parent, grandparents, domestic partners, as long as they have like an illness or a health condition where you want to take time off and care for them, and as a result you are losing income because you don't get PTO or sick leave or anything like that, then workers could apply for this program and take time off and then get some sort of wage compensation while they take time off to bond with their babies or care for their family members. A third condition or a situation where you can get PFL is a family member's relation to military deployment. And up to this year, under this program, a worker can pay up to 70% of their normal wages. But starting 2025, workers can get paid up to 90% of their wages. So almost covering their normal amount of income if they take leave. And this program supplements their income for up to 8 weeks. So I talked a little bit about this, but if you are an undocumented worker and you want to apply for either SDI or PFL, you would want to request a paper application from the EDD website, or you can ask your doctor for a paper application, or you can call EDD and ask them to mail you one, because you can't just download the paper application from the website. They have to either directly mail you one, or you have to pick up a physical copy from one of their offices or from a doctor, or you have to call them so that they could mail you one. There's no way for you to just go online and find a sample form because they don't have that. And again, you have to, if you are documented, you have to write a letter, kind of explain if you use a social, which one, what it was, and then proof of wages from your last 18 months. And then it is likely that EDD will request you for more information or more documents. And in that situation, you might want to ask us or an attorney or an advocate or another organization familiar with this for help, just so that you don't give them false information. And there's a full guide by Legal Aid at Work. There's a link here on how to apply and respond to EDD and prepare for this application. It's a link here and it's very comprehensive and very helpful. And there is a guide for every process, every step of the process in this application. And in the event that you are denied or disqualified from either getting unemployment insurance, SDI, or PFL, there is an appeal process for it. So first thing is EDD sends you something called a notice of determination, and that is the document that that EDD uses to tell you that you've been disqualified from benefits. And in that notice, they tell you the reason that you're disqualified for. They cite the regulation section that you're just being disqualified under, and they tell you that you have 30 days to file an appeal with EDD if you disagree. And so most claimants don't know that they have the right to appeal. But you do have to file the appeal within 30 days of the date of the notice. If you file late, there is a good cause argument to say that you filed late because of a certain reasons that are not due to just pure neglect or you're willingly and intentionally delaying the appeal process. But everybody has the right to appeal, and then once you appeal, your case goes to their appeals office, and then you get a hearing with a judge. We can help claimants prepare for the hearing and prepare the appeal forms. And then at the end of the hearing process, the judge issues a decision. But if you disagree with the judge because the decision is unfavorable, there's a second level appeal process for this with the CIAB. That's just to say that if somebody gets denied or disqualified at the very initial stage, don't stop there because we can help move the process further along and help people get benefits even after they've been denied or disqualified. Okay, so I'm going to stop there. And let me see the questions.
I think that the question about SDI was addressed in the
Okay.
chat.
Okay.
And just to go back, I think also to positive, like to give you a citation for the labor code about somebody who asked about whether or not the employer can stop you from sharing wages or asking employees and other coworkers about their wages. So labor code section 232A and B specifically states that employers cannot limit employees' discussion of their wages. Or discuss workplace protections. And then there are other ones that deal with being able to, you cannot require an employee to sign an agreement stating that you won't do that as well. And that's also Labor Code Section 232.5.
Okay, cool. I guess just one last thing to note for these questions is that the amount you get, the amount of benefits you get per week in all of these programs depends on your work history. And that means your income history. So how much you earned while you were still an employed worker will affect how much you can get under unemployment insurance and SDI and PFL because it looks at your overall earnings from the past 18 months. So that's why it's important to show that you have proof of wages, right? Because if you can't show that you earn this much amount of money, then it's going to affect how much you get paid in benefits. Okay.
And just the last practical point of this, because I think a lot of our clients who do come in with this, what I had mentioned, like a false statement or trying to decide between one benefit or the other. I think the biggest takeaway is knowing that unemployment states that, okay, I've lost wages. And I'm able to work, I'm looking for work, I'm physically, able to look for the jobs in my normal occupation, and I just don't have that right now, so I need benefits, which is very different from saying I am sick, I'm temporarily injured, I cannot work right now, and so I need a benefit that will carry me through this time period while I heal or while I, deal with a leave or something like that. So those two things are inherently different. And I have had clients tell me, well, SDI pays a lot more per week, so I'm going to go for that one instead. And, sometimes the case is very obvious that you're not supposed to be on one or the other. But if you're choosing it just based on how much you can get from EDD, that could lead to some problems in the future because, like I said, one is saying I'm able to work and one is saying I'm temporarily not able to work. So you don't want to get caught up in a misstatement issue because you can have a penalty amount assessed against you. You can be disqualified for future weeks, even the next time you apply for unemployment insurance. So if there's no other questions, the next portion that we're going to discuss is discrimination and harassment in California. Next slide. Okay. So what is workplace discrimination, harassment, and bullying? There is a very big common misconception that, if I don't have the most ideal workplace, and I'm fired for it for some reason, or if the employer is somehow just kind of picking on me, but I don't know why, maybe they don't think I am working fast enough or whatnot. There's a difference between that kind of harassment and that, feeling of like not being treated quite fairly versus what is illegal discrimination and harassment. And so it's a very fine, nuanced thing, but I think that's when clients call in. Of course, we empathize with the fact that if your supervisor is just, is mismanaging things, is not the great communicator that you wish them to be, sometimes yells at people. I think there's a distinction between what is harassment in the, I guess, lowercase harassment is just, it's feeling harassment and you're not feeling great about it versus what is actually protected under California law. And so under both California state and federal law, it is illegal for an employer to treat you differently, which is the discrimination part of it, whether you are a job applicant or you're already working there or you were fired because of it. But it has to be based on a protected characteristic. So this would include, harassing you by making reference to something that is a protected characteristic, for example, your race, continually over and over again to the point where you've addressed it with HR and they're still doing it. It requires on the frequency as well as the level of treatment that you're getting. But if you're being treated differently because of a protected characteristic, and then you suffer some kind of retaliation for it, or your hours are reduced for it, or the most quintessential would be is that you're fired because of it, or certain protected classes are treated differently overall, or this is having an impact on, say, women over men. Those are the kinds of discrimination practices that would actually be illegal in California that you can do something about. Next slide. Okay, I'm sure you are familiar with some of these characteristics, but we've listed all of them here, just to remind everybody that it's not just the most obvious ones. And even within these bullet points, there can be a lot of nuance as well. For example, it might not just be sex or gender, it could be the stereotyping that is involved with one sex or gender that is affecting you, or it could be, what you're perceived to be versus what they expect you to be. National origin can come in the form of, having policies where you require only one language being spoken, or refusing to take applicants who have accents when it has no bearing to the actual job. So, these are the characteristics. And if you feel like you fall under one of them or something is just not feeling right, you can come to us and we can be able to sort of distinguish if it can fit into one of these, because these are very broad categories and it can show up in a lot of different ways. Okay. And so that would be discrimination. That's, being treated differently because of one of those protected classes. Harassment is different because that is sort of unwelcome conduct. Now, whether or not that is verbal or, different policies that sort of affect you, it becomes illegal harassment when it, again, is based on a protected class. So if it is severe or pervasive enough to create a work environment where a reasonable person would consider this type of behavior intimidating, hostile, or abusive, that would be one of the elements to satisfy this, as well as having to endure such a conduct in order to, keep doing the job that you need to do. Some examples would be offensive jokes, slur epithets. I think those are the more easier ones to prove and pop out at us very quickly. But again, as I mentioned, it can be a lot more nuanced than that. It could also involve, coworkers that perhaps, it depends on who it involves and who was alerted to it and how it was handled. So all those questions come into play in terms of, if one of your clients is talking about this sort of situation, you want them to start thinking about like, well, who is around, who is aware of it, what actions did you take, and have all that information just sort of loosely in their head so that they know that when they talk to a legal provider, that that's what they're going to be looking for in terms of questions. Okay. So where do you go when one of your clients presents with this kind of thing? Of course, the safest bet would be to call us. We can always, if they don't, if they live out of our service area, or, they don't qualify otherwise because their income is too high, we can still at least give general information, which includes, if it is a state agency that they are seeking, because some laws only apply to California workers, they would go to the California Civil Rights Department. And if it is a federal issue, it would go to the Equal Employment Opportunity Commission. That one would only apply to federal workers, or sometimes, there are specific laws that favor federal versus California, which we won't delve into right now. And I wouldn't worry so much about picking the right one, in that you can always, it can get transferred over if you didn't go to the right agency in the first place. But just know that, for example, in California, you have 3 years to file your claim from when the wrong first happened, whereas the EEOC or the federal agency, you only have 300 days. And so this is an instance where, you can come to us, we can help you assess it. If you've already filed or if you wish to file, it's a very simple process to get the initial complaint in, but with certainly something that we can help draft. And if, you're looking to maybe stay at work and you need to resolve this with your employer, in a way that maybe might not escalate things, even if it did, you have a right to not be retaliated against for filing such a thing. We can also come up with some creative solutions on how we can maybe ghostwrite certain language that you can send to your employer so that all your bases are covered, but it doesn't alert them to the fact that you've already talked to an attorney. Or if it's just gotten so bad, or, depending on what you're seeking out of coming to us, we can write a demand letter from us. There's different ways to handle this before filing it directly. But even if you file it directly and that's the case that you want to go straight to them, we can help you through the process as well. Okay. And retaliation, I had just mentioned that as well. But that is basically punishing an employee for asserting a workplace right or trying to enforce a workplace protection. And that can come in many, many different forms, which is, you complain about, well, now you know that there's a law specifically stating you cannot silence people from discussing their wages. If you are somehow punished for that, or it's made known, they start, maybe they don't even say anything about the fact that you're doing it, but they start cutting your hours or giving you undesirable shifts or something like that. You can show that that is a type of retaliation for asserting a right that you have because it's in the labor code. And there are different, ways to sort of enforce that as well. The important key thing about retaliation also, I think, practically speaking, is proving it. So there are certain agencies, for example, the Labor Commissioner's Office has found that if it is just verbal evidence, it might be a little bit more difficult to proceed in that venue, but that if you say emailed, HR putting in voicing your complaint, and then you can show within, X amount of time, There's a presumption that if something bad happens to you within 6 months, it's presumed that it was retaliatory based on you submitting this complaint or trying to assert a workplace right. So always good to try to, keep things in writing, but I know that's difficult sometimes with our client population. So that's where record keeping and, making notes of your own interactions with HR are going to be very important. And then lastly, just this concept of at-will employment. We also get a lot of clients who come to us and say, they just fired me for no reason, or they didn't give me a written reason, or they didn't give me, 3 warnings before they fired me. Unless there is some policy, unless there is some kind of employee handbook, unless you're a part of a union, California is just at will employment. So you can leave that same day for any reason, and they also can terminate you for any reason. We are lucky in California that the list of unlawful reasons are very long. But again, you have to show, was it based on a discriminatory practice because of a protected class? Did I get retaliated against because I, said X, Y, and Z, and when did that happen? That's where like the fact gathering and figuring out what your rights are very helpful. But just knowing that aside from all those different venues and reasons, they can fire you without giving you any reason. They don't have to give you 2 weeks notice. You don't have to give 2 weeks notice. It's a common courtesy, but there's no law that says that. And so I think that's probably one of the biggest light bulbs that go off with a lot of our clients who come in and who don't have like a discrimination or wrongful termination case. Some things can be unfair, but they might not necessarily be illegal. Next slide. These are some retaliation examples that we've listed just to, because some are a little less obvious than others. Obviously, if you're fired or your work schedule changes, or, sometimes they might move you to a different office that's further away. It all depends on how bad it can be, what is the normal practice. It's very case by case basis. So that's why we encourage workers to come and talk to us. Okay, and same thing with what we discussed with discrimination and harassment. The same agencies would apply and the same deadlines in terms of a federal agency versus a state agency. And I think maybe Amy's, okay. Sick leave and leaves of absence.
Sorry, I have to like press the button multiple times for the slide to change. So weird. Okay, there was one question in the chat, and I think they said, could this also be reporting a workplace violence? So yes, reporting workplace violence is a protected right. I wasn't sure if everybody could see the answer, so just wanted to bring that up. Okay, so the next portion of the presentation is sick leave and leaves of absence or protected leave. So this can include asking for time off, for sick time or medical leave, or any sort of reason that's related to kind of taking care of your own health or taking care of a family member's health. Starting this year in January in the state of California, every employer is required to give all workers at least 5 days of sick leave each year, and that's 40 hours of work for employees. This applies to both full-time and part-time workers as long as they meet the 2 eligibility requirements, and that is that these workers have to have worked for the same employer for at least 30 days in 1 year in California, and they have to complete a period of employment of 90 days before they can request any actual leave. So this is just to say that you have to work for at least 30 days, and then you have to work for 90 days before you can actually take any of the sick leave. And in providing the sick leave, the employer can let you just give you all 40 hours at once. Like when you first become eligible to take the leave, they can just tell you you have 40 hours and you can spend it whenever you want. Or they can let you accrue these 40 hours over the course of a year. And as long as they have specific rules and policy in how you accrue these, then it's totally up to the employer and how they want to let you take that leave. But as long as you make that request when you're eligible, they have to give you that leave. And then again, if you do ask for the leave and you don't get it or they don't pay you the sick leave when you leave your job, that is a violation. So this is just basic paid sick leave. If your employer has any, if they provide sick leave on top of this 5 days, like if they provide more than 5 days, or if they let you start accruing right when you start your job, that's perfectly fine too. That's just giving you more than what the state requires. There are also other job protected leaves, and these fall under the federal. There's the federal version and there's a state version. The federal version is called the FMLA, and the state version is called the California Family Rights Leave Act, the CFRA. And both of these are job protected leave programs where they guarantee that when you take the leave, your job will be there for you when you come back from that leave. So this is all to just preserve your job and make sure that you have a job to come back to after you finish taking that leave. These are up to 12 weeks per year. But these are unpaid, right? These are just purely for the sake of protecting your job and making sure that you have the same job with the same position when you come back. They will not, they don't have to pay. This is not required for employers to pay you, right, for this leave. So that's why when workers take these leave, they can ask for paid family leave, right? For depending on the reason for taking this leave. And that's where the income supplementation and wage compensation can come in because they can either take SDI or they can get PFL. And then at the same time, also ask for job protected leave so that you can preserve your job and get paid wages while you're taking time off from work. There's also other forms, another program or a law called the ADA for when you need to take leave as an accommodation, and that is also a right under the law. So for these protected leave programs under the state and the federal version, you get up to 12 weeks of job protected leave for your own serious health condition or to care for a family with a serious health condition. This can be taken intermittently. You don't need to take up to all 12 weeks at a time. You can use it however you see fit as deemed by a doctor, as long as it's to take care of a medical situation. COVID-19 can qualify as a serious health condition if it results in inpatient care or treatment by a provider. And there are certain eligibility requirements for both types of leave. The CIFRA one is a lot more uh, lenient and more worker friendly. The federal version has higher qualifications. So you have to work for an employer with 50 or more employees. Starting next year, CIFRA will apply to employers with just 5 or more employees. So it's a lot easier to meet. But for both versions of the law, you have to have worked for the employer for at least 1 year. And in the year prior to requesting leave, you have to work at least 1,250 hours. And when you make this request to take a job protected leave, make sure to request it in writing because this is a legal obligation by the employer to provide you access to getting this leave and also figuring out how to get this leave. And so they should have a process in place where you can formally make this request to take the leave, and then they might also ask you for doctor's notes or medical certification just to make sure that this leave is for a serious health condition. And so in that situation, you may want to respond with the appropriate medical records. And again, because this leave is unpaid, you can consider applying for SCI or PFL for wage supplementation if appropriate. And so for the ADA, you can request to take leave as a reasonable accommodation. And this usually applies for employees who have a disability and that they need to take maybe time off to see doctors, maybe once a week or get checkups. And so this would mean that they need time off work to go as an accommodation, right, to their regular work schedule. And employers with 15 or more employees are covered as long as these workers have a qualifying disability. And there's a whole legal definition to what is a qualifying disability that I'm not going to cover today. But this is really just for employers to go through an interactive process with the worker to see if leave is a viable, reasonable accommodation for the worker. And then the state version is the FIHA, and this covers for employers with 5 or more employees. And the definition for the qualifying disability is less strict. It's just it only requires that employees have a mental or physical impairment that limits a major life activity. So there's no qualifying disabilities, and you don't have to prove, these impairments or anything. Okay. Check the chat.
There was a quick question about
Yeah.
whether or not the 40-hour sick leave applies to the employer, small employers. So it does apply regardless of the employer size.
Yeah. Mhm.
I think the biggest, the leaves and the disability and time off, it can all get very confusing, especially if you think about, well, how do I get paid? What is the protection? So there are laws that address specifically how do you get paid and to supplement it. And then there are other laws that deal with how do you get protected so that when you do come back. And so that's where the complication, but if you can separate those two, it's easier to navigate. And then secondly is if for some reason you do need to take time off and it's denied, or maybe you don't qualify because you haven't been working there for long enough, the inquiry never ends just there, because if it's part of some kind of disability that you have and you need it as a reasonable accommodation to keep doing your work, then there is no gap or time limit or other restriction. It's just that you have to show that you do have the disability, and they need to engage in like an interactive process with you to see if they can accommodate that. So that's kind of the best takeaway for that whole portion. And we will direct you to where you can find the specific rules and laws that will be helpful from the legal aid website. So
Oh,
another
wait, hold on. Sorry, one more question that just came in. If the client if they already accrued a certain amount of hours during each pay period, is this an extra 40 hours? So what I said about the paid sick leave is just a bare minimum that's required by the state for the employers. So if they give you any more than 40 hours, that's totally great, that you get a lot more sick leave. That's totally fine. As long as they give you the bare minimum 40 hours, then that's all they're required to give.
Any other questions? Okay, one thing that we did want to bring up, because we noticed that a lot of the questions that came prior to us, coming on board for this presentation had to do more with, well, where can undocumented workers look for work? Where can they, safely apply for things? We do have a worker center / work resource list where, it's more of a generic list based on location of where they could at least go to and to a trusted agency to look for work. But we don't really have, we're not like an agency that helps find jobs. So that's the resource that we have, and I just wanted to address that. But I think what we could provide are just some red flag employment practices that we've seen over the years that affect immigrant workers, especially if they don't speak the language, or they sometimes get taken advantage of by agencies that cater to that specific population. So one of the things that we wanted to raise and that we've been seeing coming through our clinics is that with the increase of remote work, there are a lot of out-of-state employers, and there's an increase of remote jobs, and there's a lot of directed sort of, apply to this job on LinkedIn, and then the person kind of disappears. I mean, there's no like any one particular rule other than trying to get as much information from the employer as you can. Except if you do happen to go to an agency, the ones that ask you to pay for a fee in order to get you a job, I think those are also sort of red flags. And we understand that, when someone is desperate for work, they will jump through extra hoops. I think our biggest takeaway there would be to try to get as much information as you can about that particular agency and about that particular employer, because sometimes they come with us and they only have like a first name and a phone number. So it becomes a little bit more difficult to then try to reach out to that employer for the worker or to file anything without that basic information. So just being aware of collecting as much as you can informally, taking pictures of notices, remembering the address if you have to like go somewhere for a workplace. Those are all important factors so that we could then, if something does go wrong, help you recoup that money or resolve an issue. Okay, and then the next slide, because we know we only have 2 more minutes, deals with, oh yeah, okay, I mentioned this already. Resources, which I see have just been posted up. One is the Job Center Worker Center, and one is something that we also wanted to address because, as I mentioned, Legal Aid at Work is an organization up north, but they have devoted so much effort, time into their Know Your Rights presentations as well as worksheets. And I feel like with this particular audience that we have, if you're not familiar with it already, it's a great place to go to. You can either select guided help. So you start answering questions like, oh, this person has problems with their wages, or it's a disability discrimination or something like that. It can guide you that way. Or if you already know, because it's obvious, like for example, pregnancy and my job, you can go to the self-help library and select it. But these sheets have been very helpful for us, especially when the client is not quite sure they want to do something or they want to learn more about their rights. We send this to them. They can then hand it to their employer. So, whatever we have not covered or whatever was not clear in the short amount of time that we could do it, we highly recommend everybody to go to this website and search between those two different options to get these really colorful, really great worksheets that can then be handed to clients. Okay. And I think unless there's some additional questions, I know that Anna had to get 5 more minutes to wrap things up, but we're here to answer any other questions either in the chat or the Q&A.
I don't see any questions coming in, so I think we're all good to wrap up the webinar. Thank you all so much for joining, and thank you, Deborah and Amy, for giving such a wonderful presentation. Just a reminder again, this webinar is recorded. Everything will be uploaded on our website, and we will be sharing materials via email. So if you attended or registered, you should receive all that information. We will be pasting the evaluation link in the chat shortly. There you go, Lynette just pasted it. So please take a few minutes before you log off or right after to fill out the evaluation, to tell us how we did, and all that good stuff. But thank you, everyone. Thank you so much. Have a good rest of your day.